Welcome to this information video that is linked to our Family Court Resource Library at the McKenzie Friend UK network. I am Philip Kedge, the director of the network, and nothing in this vlog constitutes legal advice, as you don't need legal advice and you certainly don't need lawyers in the family court. Our resource library is for litigants in person, by litigants in person, and information is offered as informed friends. You can access the Family Court Resource Library at www.contactphil.co.uk. So, in this vlog I will be discussing the must-know basic family court principles when it comes to submitting an application for a child arrangements order. Let's do it. Principle number 1. Parental responsibility does not provide the right for a parent to have a relationship with their child. It is the right of the child to have a relationship with their parents if safe to do so. That means that when you enter into the family court looking for your rights to see your children, you are already on the back foot and understanding how the system actually works. In the family court, the emphasis is always in relation to the children and not you. The sooner you readjust your thinking to that reality, the better. Principle number 2, Section 1.1 of the Children Act 1989 is the overarching principle in determining the issues which divide the parties, where the welfare of the child is the court's paramount consideration. It is not about your welfare, it is not about your wishes and feelings. The welfare of the child is paramount. Now, paramount doesn't mean nice to have or only if possible. Paramount means paramount. It is the very highest and absolute priority. Now give that some careful thought and take time to understand it. Principle number 3. Section 1.2a of the Children Act of 1989 provides for a legal presumption that the involvement of each parent in the life of the child will further the child's welfare. Well, that is potentially a positive concept to hang your case on, but don't jump up and down in joy just yet. You see, when the court states the involvement of each party in the life of the child will further the child's welfare, the court has a wide range of powers to establish what that involvement means. Involvement could mean anything from only sending cards or letters, perhaps only phone calls, and then across the spectrum of supervised and unsupervised contact to overnight stays, and all the way up to 50-50 shared care. Principle number 4. Section 1.3 of the Children Act of 1989 states that the court must have regard to all the circumstances of the case, taking into account the relevant parts of the child welfare checklist. Now, the child welfare checklist is a set of factors which are the only factors a court can consider when making any orders in relation to children. The family court is not about what you as parents want, it simply doesn't work like that. When making decisions, the court applies the factors in the welfare checklist and places different, often arbitrary, weightings to those factors when making its judgment. It is very possible that a court can make a final order that neither party expected or particularly wants. These factors will be applied with the welfare of the child being paramount. Now you can start to see how it all fits together. Now, if you are watching this on YouTube and want to explore the child welfare checklist, then click on the link in the information and comments box below, which will take you to the relevant page of our Family Court Resource Library. Principle number 5. All decisions by the court are made on balance of probability. Now, what does that mean? Well, if you put a question to be resolved to 100 reasonable people, What side of the fence would the majority come down on? The majority being 51 or more. You see, 51% as a majority is as good as 99%. Very often the decision by family court judges is arbitrary and they have a very wide range of discretion. A judge hearing the case on Monday could come down on one side of the fence. A different judge hearing the same case on Tuesday may come down on the other side of the fence. Both judges can reason their decisions and both can be right. That is why successful appeals in the family court are very rare indeed. The reality is, when you apply to the family court for child arrangements or financial settlements, you are handing your children and your finances over to the state to decide what happens to them. And very often the outcome won't be what you either expected or indeed like. You have been warned. Almost always the best route is for warring parents to bury the hatchet and to sort their own lives out between themselves. I hope that has been helpful, which leads me to remind you that for your one-stop shop with respect to any aspect of your family court case and to access the Family Court Resource Library, please contact me right now at www.contactphil.co.uk. I'm waiting to hear from you.